everybody. I had an opportunity to speak to a few of you. I was a little late. You have to love AI. Directions had me come up behind this facility on the other side of the woods. And then when I went back, then it took me through the sports complex and all those wonderful cars parked everywhere and kids not paying attention to anything. So it took me a few minutes to get here myself. But I do want to say thank you. I appreciate the fact that you are interested enough to come on a beautiful evening like this evening. If it was crappy outside, it wouldn't be so bad, but when I got in my car, it said 82 degrees, and I just couldn't believe that it was that warm outside. But thank you again for coming this evening. I genuinely hope that when you leave here tonight, that you take something with you. Not only that something's on the table over there, but also some knowledge that will be beneficial to you and to your family. So first of all, my name is Kandy Fatheree. I am the elected sheriff here in Summit County. I have been the sheriff now. This is my 6th year. Thank you. This is my 6th year, so I'm just starting my 2nd year of my 2nd term. My terms are 4 years. I am elected every 4 years at the same time that you elect your President of the United States. I've been in law enforcement now for, this is my 34th year. And that's, one of the gentlemen that said all the stars on my chest. Each one is for 5 years, and so next year I'll add another one. I'm not quite sure where I'm going to fit it, but it will go there somewhere. I am one of 2 women in the state of Ohio that are sheriffs. There are 88 sheriffs in the state. 2 of us are women, myself and Charmaine McGuffey down in Hamilton County. The reason why this evening happened is because in 2022, the law has changed. And Marissa from the prosecutor's office, she's going to talk to you about that. But what happened is when the laws changed in 2022, I got together with then prosecutor Sherry Walsh. I'm sure many of you have heard her name. She and I talked about this class, and we've been putting this class on every 2 months since I think January, either November of 22 or January of 23 is when we started. And we pretty much fill up every class that we give. Now, Sherry has since retired, and we have a new prosecutor. His name is Elliot Kolkovich. He may or may not be able to pop in this evening. He had an event earlier that I was supposed to go to but couldn't fit it in. So he may or may not be here, but he is my partner with this program. And so I will start out talking to you, and then I'll turn it over to Marissa from the prosecutor's office. She'll talk to you about the criminal aspects, so the prosecutor's opinion on the laws and so forth. And then we'll turn it over to Marv, and Marv works for the Summit County Executive Eileen Shapiro. He is a former prosecutor. He is extremely knowledgeable in the civil side of law, but most importantly, the civil side of this subject. He's very, very well versed. So first, I told you how we got started, but many people think that this is a CCW class so that you can get your license, and it's not. Okay, this is an informational class. It's a workshop, really. I am, every sheriff in the state, and myself included, we are responsible for licensing those who apply for a concealed carry license. And we still do that. And you are still able to obtain a license and renew your license through the sheriff's office. And you can do that through the app, the sheriff's app. And if you don't know what that is, there's a little card on the table that will that you can download it. It is free. It has a tremendous amount of information on the app. But one of the things that's on the app is the CCW concealed carry piece, and it talks about what you need to apply and what you would need to renew. And then you can go to the website, sheriff.summitOH.net, and you can actually apply online. You can do the majority, not all, but the majority of an application online, and the same with renewal. So we've tried to make it as easy as possible for you. However, if you must be fingerprinted, you will have to go down to the office on Talmadge Avenue at the Job Center. I think it's 1040 Talmadge Avenue in the city of Akron. That's where our office is. You can make an appointment. It's very easy. Get in, get it done, and get out. We've tried, again, to make it as convenient as possible. Bad one. $67 for new applications. If you DD-214's active retired military ID or a county-issued veteran ID card, we do waive the fee. $50 for a renewal, $50 for a replacement or a name or an address change. Okay, but again, you can do the majority of that online. So I want to talk to you about some safety issues. So first and foremost, you do need to familiarize yourself with your weapon. We're talking about handguns tonight. And so you need to know how to use your handgun. If you've taken the CCW class, you should have a pretty good idea. But for those of you who have not taken the class, I highly recommend that you take the time, familiarize yourself with that handgun, know how to load it and unload it, how to make it safe, and just in general, have a good feeling with it. Think also about who you want to access that handgun. So other than yourself, who else are you going to permit to touch it? Who else are you going to permit to have access to it? Now, obviously, these should be family members or friends or people that you genuinely trust. For me, even though my husband is a retired law enforcement officer, no one touches my handgun except me. He's been retired now for 12 years, so I don't know that I trust him anyway. Look, he's good with a broom and a mop, but I don't know that guy. Anyway, yeah, if he was here, he would laugh too, believe me. He loves being the first man and the husband that keeps the house, because he has a wife that's out there working and keeping him and living in the style which he would prefer. Anyway, you really do need to pay close attention to who's able to touch your handgun, who's got access to it, and who you want to have access to it. Okay, so a few tips. So I am a local hillbilly. I'm from Belmont County, Ohio, right across from Moundsville, West Virginia. And so we have a farm right across from the old Moundsville Penitentiary. My grandparents, when I was a child, we were accustomed to having sometimes prisoners would escape, come across the river, come right through our farm, our property. So we always had a gun out and available. There was always a shotgun and sometimes a handgun. My father lived down on the farm, and there's nobody else around. I mean, it's very secluded back there. My dad always slept, and I couldn't understand, he slept with a gun underneath of his pillow. Please don't do that. How he never shot himself, I'll never know. But the sad part is people do that, and there have been so many horrible accidents as a result. So just some common sense tips. Please don't sleep with a gun underneath your pillow. At night when you're sleeping, some of you are going to go, ooh, I don't know about this, but I would prefer that you put your safety on, that handgun at night when you're sleeping. Also, you can have it loaded, but don't have a round chamber. And I'm going to explain all this to you in just a second. And then the third thing is, we don't recommend that you have that handgun in the drawer beside your bed. The sad part about having guns in the home is that many times you've heard that people have shot someone that they love. If you are sleeping and in the middle of the night you hear a sound and it startles you, and depending on your state at that moment, you may assume that someone has entered your home and that there's a danger. If that handgun is loaded, chambered, and in a rapid area that you can reach it within seconds, you could possibly use it and kill someone that you love. By having a round, having it loaded but a round not chambered, also having the safety on, and having it maybe on the top of the dresser across the room, it gives you those few seconds to spring up out of that bed and get your head cleared before you put your hands on something that can take another person's life. It's only a couple of seconds, but it's enough to save somebody that you love. I can't tell you how many times that we've had people that, the kids come home in the middle of the night, you didn't know they were out, or an adult child returns to your home because they got into an argument with their spouse, and they have a key to your house because it's where they grew up, and they come in and they didn't call you because it's 2 o'clock in the morning, and the next thing you know, you're hearing a sound, and a horrible tragedy occurs. So that's why we make this recommendation. The other thing is where you store your handgun. There are so many different ways now to store a handgun, but children, every year over 300 children get a hold of handguns and they shoot themselves or somebody else. We just had that happen here just in the last couple of weeks. If you watch the news, a brother, I think he was around, I want to say he was around 11, shot his 7-year-old brother. It happens. It happens far more than what we want it to happen. And across the United States, 300 children getting their hands on guns and accidentally killing themselves or somebody else. It's preventable. So I did say that there are a lot of different advancements in storage. So you've got keypads, Bluetooth locks, biometric locks, and then this evening before you leave, we will give you a lock as well for your handguns. At a minimum, use that trigger lock that we're going to give you. If you don't have any of the rest of them, at least use that. Also, if possible, if that gun's not on your hip, store your ammo and your gun in 2 different locations. So again, kids can't get a hold of them. And also, talking about the children, how you carry that gun is also important. Where you carry it at, where you store it at. When it's been now about 12 years ago, one of my deputies happened to be down on Arlington Street in Akron, and he just happened to be at the location at that time. And I don't know what your religion is, but I truly believe God put him there for a reason, because the father was about ready to lose his mind. A father with his 3-year-old son in the back seat in his car seat. Father had his gun in his gym bag laying on the floor behind the driver's side. Did not believe that 3-year-old in that car seat could reach down and get that gun. But while he's driving down Arlington Street, that 3-year-old reaches down, gets that gun and shoots himself. The father instantly stops in the middle of the street, pulls the child out, he's screaming. My deputy happened just to be there right at that same time. He did everything he could to save that child, and he was unable to. The sad part is, it could have been prevented, but what is even worse is that father. Can you imagine how he felt and how he feels to this day? But then there's another part of that. My deputy had a 3-year-old son at home, and he went home with that 3-year-old son that night. It bothered him. I had to have him get help for a couple of years. Where you put that gun, it's so important. Just a few things. Also, how you carry it. I said, don't leave it in a gym bag. If you're going to do that, put it in the front seat where they can't get to it. Also, I highly encourage men, please have a holster. You can have an inside holster, you can have an outside holster, one underneath your arm. Put that gun in a holster. And the reason why I say that is, we have a gentleman not far from here. I think it's been about 2 years ago now. He went out, he bought a brand new Glock 9. He did not have a holster. He dropped his wife off at the front door of the store. He parked the car, he reached down, he grabbed the gun, he slid the gun down in front of his pants. It did go off, and it hit him in the thigh. He is alive, and he's fine, but this is a man that was former military, had a lot of experience around guns, and still, these things happen. So don't be like the Wild Wild West. We are not like what's on TV. It's not real. We don't stuff them down the front of our pants or down the back of our pants unless they're in a holster. That holster prevents them from accidentally going off and you from accidentally shooting yourself. Now, ladies, carrying a gun. And I forgot to bring mine tonight, but there are purses that are carry purses. You can buy them. You can get them anywhere from $30 to $300 or $400 if you want. I have one that looks like a Coach purse. It's 30 years old. It actually almost looks like a saddlebag that goes on my old Harley. You can get them, and they have an area in the purse designated with a zipper for you to put that gun in a holster in your purse and zip it up. Now, the cheap cheap purses are not going to have a lock on it. But if you get a quality purse and you're going to carry that gun, it actually has a lock so that you can put that gun in the purse. You can actually lock that zipper, and nobody can get into your purse when you've got it at the house or if you're out and about. Carrying it when you are out shopping, you don't want it locked, obviously. You want it to be accessible. But buy a purse. And if you can't afford an expensive one, you can get them on Amazon, $30. I mean, they're not expensive. So it's all what you want to put into it. But if you're going to carry a gun, have it so that you don't want to just throw it in that purse. I mean, we got enough junk in there. You know, what you don't want is anything to happen to it. So I really do encourage you. That's it? Okay, so before I turn over to Marissa and Marvin, 2 more things I want to talk to you about. When you are driving and you are stopped by any law enforcement officer, when those lights go on after your heartbeat comes back down again, the things that I want you to think about and remember. We will automatically assume, regardless of what you look like or how old you are, we will automatically assume every single one of you has a gun on you. Because constitutional concealed carry no longer tells us that you have the right to have a gun. So now we automatically assume every single person has a gun, whether you do or not. So we are going to be very heightened, because there are 2 areas where law enforcement are killed more than any other thing that we do, and one of them is traffic stops. More officers are killed in a traffic stop than in anything else that they do other than a domestic violence call. So understand, us knowing that the high probability is that you have a gun, and so we are going to be very, very cautious as we approach it. So if it is during the day, do not reach around looking for your license and your registration and everything else. When you get stopped, put your hands on the top of the steering wheel and just leave them there. Roll your windows down, put your hands on the top of the steering wheel, wait for the officer to approach. They may not approach you on the driver's side, they may approach you on the passenger side, and they may not come in front of the entire window. They'll stay behind the post. It is a protection, and that's how we're trained. Protect ourselves. So they may come to the post, lean forward, look in, and then engage with you. It just depends. You may also get 2. You may get 1 on each side, an officer. But have your hands on the wheel. It will immediately lower their tension, and if their tension is lowered, it's a much better experience. In addition to that, if you have a gun in the car, either on you, beside you, in the console, wherever you've got it at, as soon as they get there, they're probably going to ask you, but if they don't, please, I encourage you to volunteer that information. Let them know that you have a gun if you've got a gun on you. And if you have a CCW and you do not have your gun on you, tell them that too. Okay? At night, if you are stopped at night, turn your dome light on so that they can see inside your vehicle. Again, it lowers that temperature and everybody can leave safe. The scenario should be the same. Just turn the dome light on, don't go ruffling around looking for stuff in the car, hands on the top of the steering wheel, and then interact with your officer. It'll be a much better experience for everyone, them and for you. Those are my safety tips as you travel through your life with a gun and interacting with law enforcement. Marissa? Yes, sir.
It used to be when the officers ran your plates that were workshop, even at CCW. Does that still?
It still does, yes.
So they will already know.
That's why I say that if you have a CCW, they will have ran your plates, they'll know that you have a CCW. They're gonna ask you if you have a gun. And if you do not have a gun, let them know that right away. If something happens and they don't ask you, just tell them right away, I don't have my gun with me. And believe me, you'll watch them relax a little bit more. Okay? Any other questions before I hand this off? All right, well, I want to thank you. I'm going to hang around. Marissa's going to talk with you, and Mark's going to talk with you, and we will be here for questions afterwards. Thank you, Marissa.
Great, good evening, folks. My name is Marissa Pappas. I work for the Summit County Prosecutor's Office for Elliot Kolkovich. My job with the county is to run the grand jury. So what we do is we screen all the incoming felonies in the office, and if appropriate, we present the case to the grand jury. And last year in Summit County, we received 5,400 cases that were felony cases for review. So we receive a lot of stuff, we see a lot of cases, and when the law changed, we were kind of tasked with learning this new law and being prepared to teach law enforcement in the county about it. And then Sheriff and then Prosecutor Bevan Walsh, they started these workshops, and I think, Troy, help me out, was it the first one in Twinsburg at the VFW?
Yeah, Northfield Center.
Okay, but it was just me, and the question questions very naturally all kind of wanted to talk about what Marv's going to talk about. So then we very quickly brought Marv in to kind of split the task here, because we're going to talk about the law, and then we're going to talk about standard ground and castle doctrine. And I always ask Marv to jump in if there's something I forget, and vice versa. So the law, again, Senate Bill 215 changed the law in 22. Prior to that, it was 2004 that we became a permit state. So everyone was open carry, right? It was 2004 that we became a permit state, where if you wanted to carry concealed, you had to have a permit. Who are my permit people in the room? There's usually a lot of permit people. Okay. The permit system is still in place, just like the sheriff told you. A couple of reasons. One, reciprocity. If you're traveling in other states, some states, not all states, will recognize your permit. So if you're going in another state, you want to carry, and they recognize your permit, it would be beneficial for you to have a permit if you're going into another state that doesn't have constitutional carry. Also, there's a training component. The folks who got their permits, you had to go to class, right? There was a range component, you learned something. We obviously think that's a great idea. If you're going to carry a weapon, that you learn about it and you learn some gun safety. This line here that it applies to improper handling, originally the way this was drafted, we didn't think it was going to apply to how you can carry in a car, but it does. So it applies to how you can carry on your person, and it applies to how you can carry in a vehicle. Constitutional carry only applies to handguns, okay? Not long guns, not rifles, and not restricted firearms. So if you have a firearm that's been modified in some way, it's an illegal firearm, even if it's still a handgun, it's not going to be something that you can carry as part of constitutional carry. It's only lawful handguns. So what Senate Bill 215 did was add a code section to our revised code, which is 2923.111. And I think that it's part of what makes this really hard for folks to try to learn on their own. If you're just trying to browse the revised code, which is not user-friendly, this made it complicated, because if you look at the statutes that already existed that tell you what you can and can't do with a gun, you're not going to see the words constitutional carry. You're not going to see the words qualified at all. You're not going to see any changes to those codes. What Senate Bill 215 did was kind of squeeze this one in that defines what a qualified adult is. And it basically says that everywhere in the revised code now where you see, unless you're a valid carry concealed permit holder, you can interpret it to mean unless you're a qualified adult. So a person who's a qualified adult is going to have the same rights and responsibilities as a person who has a permit. They're going to have the same privileges as somebody who has a permit. And there's going to be similar consequences for conduct as someone who has a permit. So all of this here is directly from the code, and it basically says what I just said, that it really goes to some great lengths to say that a person who's a qualified adult has the same privileges as a person who has a permit. And you're no longer required to have that permit anymore if you're a qualified adult. So what is a qualified adult? A qualified adult must be 21 years or older. That's the first one. You can't be prohibited under this federal statute, which is the 18 U.S.C. chapter there. So we've adopted some federal statutes, or some portions of one in our state laws. You can't be prohibited by that, and you can't be prohibited by our state statute on who can have a gun. And then you must satisfy most of 2923.125, which is our statute that tells us what we have to have and what we have to do to get a permit. So if you meet all of these things, you're going to be a qualified adult who can participate in constitutional carry. So again, got to be 21 and not prohibited by this federal statute. What's the federal statute say? You cannot have been convicted of a crime punishable by more than a year. You can't be a fugitive from justice. Typically, a fugitive from justice means somebody who is wanted by police. They know they're wanted by police, and they're doing something to avoid the police. You can't be an unlawful user of or is addicted to any controlled substance. Anybody ever fill out a form at a gun store before? Some of these should sound really familiar because they come right from that form. What's it called? Like a 44, 73, 70 something? You guys know that. So no. You can't have been adjudicated mentally defective or committed. You can't be an illegal alien. You cannot have been dishonorably discharged from the military. You cannot have renounced your citizenship. You can't be subject to a protection order or convicted of any misdemeanor domestic violence or any felony domestic violence. So if any of these things apply, you're not going to be in our definition of a qualified adult. You cannot participate in constitutional carry. So you have to be 21, not prohibited by the federal statute, but also not prohibited by our state statute, which some of these are going to start to sound repetitive. Can't be a fugitive from justice. In Ohio, if you're under indictment for or convicted of felony offenses of violence or felony drug offenses, you cannot have, acquire, carry, or use a gun. We call it being under disability in Ohio, but you can't have a weapon, period. In Ohio, if you have an indictment or a conviction for felony offenses of violence or felony offenses for drugs. You can also not be drug dependent or adjudicated mentally competent or defective, or committed. So again, 21, not prohibited by the state statute, not prohibited by the federal statute, and then these are the things within our statute that says what you have to do to get a permit that you must meet if you want to be a qualified adult. You gotta legally be within the United States. Again, 21 years or older. You cannot be under indictment or otherwise charged with any felony, any drug offense, misdemeanor offense of violence, negligent assault, or falsifying or possessing a revoked or suspended CCW permit. Can't be adjudicated mentally defective. Can't have a suspended CCW permit for a misdemeanor conviction. This is very specific. It is for violations of the CCW law and the improper handling law. And that's the only suspension. So like if you, in certain cases, when people get charged with certain types of crimes, your permit may get revoked. If, let's say, that gets dismissed or pled down, that doesn't necessarily mean that you weren't gonna fall into this, unless it was for carry concealed violation or improper handling violation. You can't have convictions for any felony drug offenses, assault on a peace officer, no misdemeanors punishable by imprisonment for 1 year, any misdemeanor offenses of violence within 3 years, 2 or more convictions for assault or negligent assault within 5 years, or resisting arrest within 10 years. Can't be subject to a protection order or have been dishonorably discharged from the military. So again, some of those really repeat themselves over those 3 statutes that we're looking at. But if you meet all of these things, you're a qualified adult, and whether or not you have a permit, you can carry. So there's a couple of changes that came for permit holders. Those of you that have permits, anybody have them from before 22? Okay, so did you have to have your permit on you all the time because you were carrying, right? Who else has a permit from before 22? If you got pulled over, what were you supposed to do if you had a gun in the car? Yes, so the first words out of your mouth was supposed to be, I have a gun in the car, it's loaded, I have a firearm. You no longer have to do that. They've switched it. So now you only have to disclose if you're asked. But kind of like the sheriff said, if you have a gun and you're pulled over, tell them. But it is a crime now it was a crime before and it's still a crime not to tell them. So failing to disclose previously was a first degree misdemeanor and the duty was on the person to disclose. They've switched it now, it's actually a misdemeanor of the second degree and you're only required to tell them if you are asked. And they are asked. I watch a lot of body camera and it's pretty much the first thing they say after hello. So they're asking. And it is, again, it's an arrestable misdemeanor offense to fail to disclose. So we have a couple hypotheticals here. And while Bill is at the upper deck, and he has a loaded handgun concealed in his waistband, Bill does not have a concealed handgun permit, but he is a qualified adult. Is Bill permitted to carry the loaded handgun in a bar? And this is where I ask for audience participation. Do we think that Bill can carry in the bar? Is he a no? Is he a no? Yes. It is a bar. It has a liquor license. It's a liquor premises? No. The answer is it depends. Okay. Does your answer change if I tell you that Bill has not had a sip of alcohol? Yes. No? Does it change your answer? Okay, right? So it's not necessarily true. So if you are in Ohio, you can't have a firearm or liquor premises. Which means they have a liquor permit, they're selling alcohol. Scroll down though, it says, unless you're a valid carry and concealed permit holder. And now to say, unless you're a qualified adult, okay? So if you're not drinking, you can't have your firearm in the premises. But if you are, what if you have a beer? Okay. What if you have a sip? Sip. Nope, that's right, none. You can't have any alcohol at all. It's kind of skipping around here. Obviously, if you're impaired, you can't have a gun. But this particular statute says that you can't get, if you're just consuming any alcohol at all. So if you're a valid carry concealed permit holder or a qualified adult, and you're having zero alcohol, zero drugs, zero alcohol, you can carry in the premises. But if the second you have a sip of alcohol, you are in violation of this chapter, and it is a felony to do so. Okay? Any questions on that? Yeah, go ahead.
Yeah, my question is, this is actually happened when my coworker, he doesn't drink, he was a designated driver, and he went to a bar, somebody was highly intoxicated, some to beer out of him. Police were called, he had to explain he was not drinking. And, you know, yes, you got scenarios like that can happen.
Sure.
How do you prove, they don't need to, follow the machine.
Not unless it's a driving offense, not typically, no. But I mean, if you're in a bar, you can show, hey, I don't have a bar tab, or my bar tab only has Diet Coke on it, or, you know, argue that you're not impaired. Now the problem is if you've been buying rounds for everybody all night long, and your tab's, $100, you might be in trouble. Again, I'm giving you what the letter of the law is here, but at the end of the day, you want to make wise decisions. If you're out and you think there's a chance you might drink alcohol, I wouldn't take it. Wait, we're going to talk about that in a second. Any other questions? Hold that thought. Stay tuned. All right, so Wyatt Earp is traffic stop for an equipment violation. Officers smell marijuana, and during the search, they find a loaded American Arms AM-15 on the passenger floor door. Earp does not have a carry concealed permit, but he is a qualified adult. Don't read ahead. We're looking at number 1. Don't read ahead. Don't read ahead. Look away. Okay, is he allowed to have this firearm on his floorboard? No. Why? Right? Why else? Anybody else have another idea? Because it's not a handgun. This is a rifle. Okay? Not a rifle. Or it's a rifle, so it's not a handgun. You can't carry it this way. So going on to number 2. What if we say now instead of this rifle, it's a handgun? No? Why do you say he's under disability? Yeah. It doesn't put him under disability. It does not put him under disability. So if he's a qualified adult and he has the handgun in the car, he's still a qualified adult until he gets charged with some offenses, and he's probably going to get charged with. And once he's charged with those offenses, he's not going to be a qualified adult anymore. But simply just having marijuana in the car isn't going to negate his qualified adult status. It's not, trust me, I'm not advocating for Wyatt's conduct here, but just having the marijuana in the car, getting pulled over with a gun, doesn't immediately negate his status. What's gonna happen after this is gonna cause him problems with his status as a qualified adult, but he's actually still a qualified adult. So let's change it from marijuana to cocaine. Because we have recreational marijuana in Ohio, we do not have recreational cocaine. What if it's cocaine? Does that change your answer about whether you can have the gun? Still, again, technically no. Again, I'm not advocating for this, but technically no. He's still going to be okay. He's a qualified adult. But what happens once he's charged with a felony or then indicted for felony possession of cocaine? What is he no longer? And then actually once he's indicted for drug offenses, he's under disability. So there's going to be consequences to this traffic stop, but in the moment, just the drugs being in the car doesn't take away his status as a qualified adult, but the consequences of being charged and indicted for these other things will impact his ability to carry.
So my other question is, when you say officers smell marijuana, we're talking about the raw herbs or the smoke of the car?
Well, when I made this PowerPoint, it was before our laws changed. We just had a court ruling that said even the smell of marijuana is still going to grant officers to search the car. But you still, even with recreational marijuana, you can't drive around with smoke pot.
That's what.
Yeah, you can. But it's not going to affect his status to carry. So I kind of gave away the answer number 5 there, but that's, again, if he's impaired, it doesn't matter what his status is. Qualified adults, carry concealed permit holders, no one can have or transport a loaded firearm in the car if they're under the influence of alcohol, drugs, or a combination of alcohol and drugs. It is a felony to do so. So when we're talking about impairment, kind of your status as a qualified adult really becomes moot. Because you can be the most qualified adult, but if you're under the influence of alcohol, drugs, or a combination, you can't carry a loaded weapon in the car. Any questions about this one? Okay. So Billy the kid is out of apples. He goes, hey, I had to Google all these slingers when I did this. And Billy the kid is out of apples. He goes to Giant Eagle to restock, and he takes his favorite 6-shooter with him. It's concealed under his jacket. There's a sign at the entrance pursuant to revised code 2923-1212 stating, unless otherwise authorized by law, no guns allowed. Billy is a qualified adult. Don't read ahead. Can he carry into the Giant Eagle? No. Yes. Yes. No. The answer is no. But.
So I have a question.
Sure.
I'm sorry, it's valid. It's under the original CCW law, it had to be very specific signs. You'll see signs now that are not compliant with the original law that just say no weapons, right?
You don't, the language is not statutory. The language can say whatever it wants to say. The rule is that the sign has to be placed somewhere where people are likely to see it upon entrance. It must be conspicuous. So, you know, if you go into a store and there's no signage, and on the back door at the very bottom corner, there's a teeny tiny little sign that says no guns, you're probably going to win that one because it's not placed somewhere where people are likely to see it. But there is no statutory language that must be included. There's just the placard has to be somewhere where people can see it, and it has to say no guns. But if you bring a gun into one of these facilities that says no guns allowed, you're not charged with like a carry conceal violation. It's actually a violation of our trespass statute for not complying with signage. And we'll talk a little bit more about signage. It usually comes up with Mark's stuff. But you know, private businesses can place those placards up, and we do have to abide by them. Go ahead.
It says unless otherwise authorized by law.
Qualified adult status does not trump one of these signs. That's not what that means. It means like law enforcement and things like that.
We didn't say that, because I guess myself reading that, we got a CCW.
No. No, that means like law enforcement. Yeah. Even having a permit or being a qualified adult, if there's a sign, you can't carry inside. But again, if you are caught doing so, it's going to be a violation of the trespass statute. Other questions? Okay, so the bottom line, go ahead.
So they have a sign for no public, like I can't like walk into Giant Eagle with my gun, but they have a non-sworn officer, like a security guard that has a gun. How does that work? Because they're not sworn in by law. They're just a civilian that has a job and has a gun. So how does it seems kind of like an unfair situation?
They're there for security. Probably hired by the people that hung up the sign. Yeah. But private businesses can enforce these rules. And if they want to have armed security, they're not going to apply the placard to that. Yeah. The bottom line with qualified adult status is if you could meet all the criteria to have a permit, in Ohio you are now treated, so you have one.
So the transportable weapon doesn't have to be in a zip bag in the back any longer. It can be holstered and carried, no different than a CCW person.
Correct, as long as we're talking about a handgun. Yes, you can have it accessible to you in the car. You can be on your person, you can be touching it. If it is a rifle, it cannot.
Even unloaded?
Say again?
Unloaded?
Unloaded rifle?
Yeah, can you transport it? Oh, sure.
Yeah.
But, ammo one place.
The argument's gonna always come down to, which I think is a question of fact for juries, is accessibility. So, you know, for example, something we see a lot is I'm getting pulled over by the police. And I very quickly eject my magazine and the chambered round, and when the police get there, there's, you know, a magazine on the passenger floorboard, a gun at my feet, and a live round in my cup holder. And clearly just, you know, quickly just, you know, unloaded that. But no, if you're trying to just be responsible, if you're, especially like in SUVs where there's really no distinction between car and cargo area, it's all about accessibility. You know, if your rifle is way in the back in a zipper case and your magazine is in the back seat, I don't think anyone's gonna say that you had, those were accessible things to you at the time you're driving the car. Go ahead.
So you can carry anything up as long as it's not loaded.
Say it again.
You're allowed to carry any gun as long as it's not loaded.
There are some misdemeanor violations for carrying, this is gonna buzz if I stay close to that speaker. But typically for felonies, it's always gonna be a loaded weapon.
I can't think of anything where it's unloaded, that it's a problem under.
There's a misdemeanor improper handling for like not carrying a long gun in one of the right ways, and that covers unloaded guns.
Oh, yeah, that's not right.
Yeah. Alright, I think this might be, if you were by that speaker, do you want to come aside?
All right. Can you hear me all right? Well, this is, what we're going to be getting into now is the self-defense aspect of this. Marissa has a lot of experience with this. Obviously, she indicts all kinds of felonies, so she actually is much more knowledgeable about this area than I am. But I am a firearms instructor. I've given lots of these classes, and so I've given it certainly a lot of thought, and I've been carrying a firearm for many years, but I'm not law enforcement, so I don't have that experience. Certainly the sheriff and Kandy, the sheriff and Marissa, you know, they're going to be able to chime in quite a bit on some of these subjects where you may have questions. So I've always struggled with my approach to this section, which is kind of why I'm reading, because, or at least have some cheat sheets here, because there's so many aspects to dealing with self-defense. There's so many different scenarios you can think of, so many various ways you can talk about certain aspects of, should you defend yourself, should you shoot, should you not shoot, those types of things. And as the sheriff said, we've been doing these now for several years, and I've really kind of changed my approach various times through doing these. What I hope to give you is not just the black letter law, but kind of hopefully encourage you to think about how that law impacts how you think about what tactics you might use, how you carry when you're out in the world and you know that there's a possibility that something may happen. How do you go about thinking about what's my reaction going to be? Because that's what you want. How you want to think about the law is, how do I protect myself by getting the least amount of trouble possible? Because certainly, as we see from many cases, people carry, they're not the wisest about how they do it, or even, they have guns in their home for self-protection, and they don't go about it right, and they get themselves into trouble, kill somebody, or even just, get into trouble in other ways without even discharging it. So along those lines, I hope our discussion gives you a way to think about kind of putting parameters on, how you might use your firearm if you think you had to. We're always getting the question, well, when can I shoot somebody, or something along those lines? And it's a really difficult question because there's so many facts that go into it, and we'll talk about that. It's all factual based. You hear about murder trials or homicides, and those trials can take they can take a week or more to get through them because they're going through every little detail, every little fact, and that's what happens when something like that, when somebody discharges the firearm, somebody's either hurt or killed. It becomes a highly factual matter, and it can take a long time to even sort out, especially when people have a relationship with the people, with one another. So hopefully we can give you some real life examples tonight. I've got a few cases that, you know, I tend to use, so we'll be talking about those. But one of the things I do want to talk a little bit about is to be aware of kind of the general atmosphere in the community, because I've felt this in classes that I've given and in talks like this, where depending on what news channel you watch, you can certainly get a feel for that there's a lot more crime out there than there is, although I totally admit that there are spots, certainly hot spots in various communities where you don't want to be there walking around at night. Whereas, I mean, frankly, you know, Twinsburg, my understanding, because I'm not familiar with this, I'm in Akron, my neighborhood, even though I'm in a city, I walk around at midnight routinely. So it doesn't bother me, but I'm in a good neighborhood, admittedly. There are neighborhoods I would never do that in. So it really depends, but you should be aware that, you know, that's a real thing that you could be misled by watching the news to think that there's somebody waiting around every corner. It's probably not the case, but it depends on where you are. And certainly the crime rates, at least as reported by the FBI, has come down considerably from the late 80s to early 90s. If you look at a graph, it seems like all of the crime rate has gone down. Other than during COVID, it did spike a bit, but it's back down a bit. I asked the sheriff to maybe give you a little bit on that, because I know that she sees it, and certainly Marissa sees it also.
Yeah, I would say that crime definitely has gone down. For the last 2 years, you know, we follow the crime in Summit County, and violent crime for the most part has gone down. Many of the crimes that have gone up are drug related. It's possession more so than anything else. But as far as like murders, assaults, rapes, arson, they have gone down. And the other thing is, even with the murders, the number that we have in our county, a vast majority of them are gang related, and they are people who know each other. They're not shootings that occur. For the most part, they are not shootings or murders that occur to a non-close person. So in other words, not that the probability isn't there, but if shootings are occurring, they are occurring between people who know each other and not strangers. So I would encourage you not to assume that, you know, it's rampant. It's really not. I'm not saying we don't have crime, we certainly do, but it's not like it was. And it has been coming down in the last few years, and nationally it's coming down. Now there are hot spots. There are areas where crime is up. In our county, some of the highest crime locations are in the city of Akron, and as Akron borders the city of Barberton, that is a very large crime area. But as far as the rest of the county, there is crime, but it is not violent crime, and there's not a lot of it. So I don't know if that, it kind of explains, you know, what it is, but you can go on the FBI's website or the Department of Justice, and you can look up the crime statistics across the nation. You can also get them for the state of Ohio as well, but it's, you know, just Google it, but the FBI puts it together, and it's really not as bad as what you would think. I was really quite surprised. But in relationship to that, I can tell you that crime is going down in our county significantly, because for many, many years we were booking in well over 15,000 people a year, and we are down, we're hovering between 9,000 to 10,000 now, the last couple of years. So, and the kind of crime that's coming in there for a while, and especially under COVID, was a lot of murders. But even they are coming down. But a lot of it is really drug related. So my recommendation for you is when you are out and about and you are caring for your safety, the probability is that if anything happens, it's more likely going to be somebody wanting to rob you for drugs than it would be for them shooting you. Okay?
Thanks, Sheriff. So, kind of another aspect of that is that, also if you look at the FBI statistics, the vast majority, maybe Marissa wants to talk about this because I think that she sees it quite often, is, and the sheriff mentioned it, is generally people that know each other. It's not the random crime, although that happens. And I bring that to your attention because that's really important, because that's where you see a lot of the shootings. People that know each other are shooting each other. They get in arguments. They are doing drugs, drinking. They get in an argument, and all of a sudden somebody puts a gun into the mix, and then things go really south. And that's one of the things, as a gun owner, you need to realize. People, I would assume you may see this, people that get indicted for that go, well, I was just trying to, we were having an argument, and I was just trying to kind of settle things down by threatening somebody with a gun. It's the craziest thing, but it happens all the time.
If you choose to brandish your weapon, and obviously God would use your weapon, you have to be really sure. And not to mention, then you have to have a bunch of people Monday morning quarterbacking your decision. You're gonna hope that the police who come on scene agree with what you did. And then when they go talk to their law department and their prosecutors, you're gonna really hope that those people agree with what you did. And then if it goes to grand jury, you're gonna hope that 9 people agree with what you did. And if it goes to trial, you're gonna really hope that 12 people agree with what you did. That's a lot of people that you're hoping agree with your decision to either brandish a weapon or use a weapon. So I think Mark will probably say this a couple times during his presentation, is try not to if you don't have to. I think some people romanticize like being the hero and like pulling out that gun, and it can be a very expensive and very, cost you your liberty in some cases, depending on what happens. There's a couple things I did want to add on to what the sheriff said. I will echo that overall crime rates are down, homicide rates are down within the county, overall crime is down. But there are a couple things that I have noticed that I think are on the rise. And one of them is firearm-related road rage incidents. Without question, on the rise. So if you're an aggressive driver like I am, just keep it. My husband says I'm a bad driver. I think I'm an aggressive driver, an assertive driver. But keep that in mind. We're seeing a ton of that, a ton of just road rage incidences where people are brandishing firearms and shooting firearms during a road rage incident. And that is a situation where it is usually strangers, and they just tick each other off driving, and it goes super south very fast. But other than that, I would agree that most crime is down. Just crime overall, homicides are down. But yeah, there's still plenty. Some days I feel like there's more crime than ever, but the numbers would say that it is down. And then the last thing I'll say before I give it back to Mark is, yes, you can look at the FBI website, and there's crime statistics, but also Prosecutor Kolkovich issues an annual review that is available on our website if you want to know what's going on in Summit County. It breaks it down by what we did by the year, type of crime, type of prosecution, that's all available online.
So those are really the difficult cases where people know each other, they've got a history. Trying to sort out those facts can be awfully difficult. And frankly, in general, defending yourself from somebody that you don't know, that's like an armed robbery situation or an intruder into your home, in a lot of ways, that's the easiest case out there. In a lot of ways, not always easy, but that's the, those, when we talk about the Castle Doctrine, we'll talk about that a bit, but generally that's the easiest thing. So my opinion in this regards is if you're carrying a gun or have one available in your home, you need to be able to keep a cool head and, in difficult situations, because that's where a lot of people get into trouble. They let their emotions take over. They bring out a gun in the wrong situation, or they don't understand the ramifications of bringing that gun out. And that overreaction, routinely gets people into trouble. Especially if I certainly suggest and encourage you to keep an eye on cases that you see in the news where somebody is claiming, well, I shot somebody in self-defense. See how those cases turn out. In addition to that, keeping an eye on that's a good idea. It gives you can learn from other people's mistakes, or frankly learn where people have made actually a good decision. The Ohio Supreme Court, their website, you are able to search for, it's going to be Ohio Supreme Court cases and all the district courts of appeal. So just about where somebody's claiming self-defense, especially if they get convicted, it's always generally going to go to at least the first level of appeal. So in Summit County, that's the 9th District Court of Appeals. But the Ohio Supreme Court website has a good search engine on there, where if you go there and you'll see, if you go to the Ohio Supreme Court website, there's a banner at the top. It's got drop-down menus. The one that says cases and opinions, drop it down and go to opinions and announcements. You can search there for, say, self-defense, Castle Doctrine, really anything you want to search for, but it's a pretty decent website for getting those things. I highly encourage you to have a look at that and research some of these things. If you're carrying, it's going to make you hopefully feel better about your knowledge in this area. So with that all said, we're going to watch the first video here, or the video.
Paul District Attorney David Prater says, first off, he wants to say his office will defend a person's right to defend themselves, even if that includes deadly force. He says, however, in this case, the pharmacist crossed the line. I want to let you know that some of the surveillance video you're about to see, some may find disturbing. The May 19th robbery of Reliable Pharmacy was all caught on videotape. 2 suspects came to the front door. The first man pointing a gun at employees. The second suspect, 16-year-old Antoine Parker, was not armed, according to prosecutors, but was putting on a mask. The store pharmacist retreats, grabs a pistol, and starts shooting, hitting Antoine Parker once in the head. The pharmacist, Jerome Ursland, then chases the armed robber down the street, firing 2 more shots. Approximately 15 seconds later, he comes back inside, walks past Antoine Parker, who prosecutors say was lying unconscious on the floor with a bullet wound to his head. Jerome Ursland grabs another gun. According to prosecutors, walks up to Antoine and shoots him 5 times in the abdomen.
Though Jerome Ursland was justified to shoot Antoine Parker in the head during the robbery attempt, Mr. Ursland is accused of exceeding that lawful authority to employ deadly force when Ursland shot Parker 5 times in the abdomen with a .380 caliber pistol after the failed robbery.
And the medical examiner says that Antoine Parker most likely would have survived that gunshot wound to the head. He says it was the 5 extra shots to his abdomen that killed him. Live downtown, Mark Cochran, Eyewitness News 5.
Unfortunately for Mr. Ursland, he was tried for murder and convicted of murder. The appeals court held it. He's been trying to get out of prison for a long time now, and it doesn't appear that he's going to have much success. So again, what started out as a justifiable use of deadly force went south really quick because, frankly, my view is he didn't keep his head. He should have known that you can't just continue to shoot somebody when they're down. If they're no longer a threat, you can't keep shooting. That's the key.
In Ohio, in Ohio, there's also
So, yeah, we may talk about some cases just like that later on, where, you know, as long as, if there's no threat anymore, there's no threat. You can't say, well, I was defending myself. So before we get into this, because I've already talked a little bit about some of this. You know, every situation is different. There's lots of gray areas. Some of the considerations that you want to take into account, you know, if you're carrying, if you're using keeping a gun at home, is, or you know, if somebody is attacking you, or you believe they're attacking you, you know, do you see a weapon? As we were talking about earlier, it's highly unlikely, although it's possible, they're going to get attacked on the street. It happens, but it's not that common of a thing. If you're carrying, if you can't keep your head straight, you know, you don't want to be shooting somebody that's maybe coming up even to ask you for money. Maybe they're really annoying, but you know, you can't shoot somebody in self-defense because they're annoying to you. So you have to be really careful. Do you see a weapon? Is there really a threat to you? If you're shooting, do you know what they teach you in all the classes? What's beyond your target? Are there people back there? All these type of considerations. You know, frankly, is a warning shot going to cause you more problems than it's going to solve? All these types of things. Don't overreact. Don't introduce a gun into a situation that doesn't call for it. Family disputes, again, keep a gun out of it. If you have to call the police to, you know, if something's going south as far as fist fights, do that. Don't enter a gun into the situation. And don't underestimate the negative consequences of even a justified shooting. So if you can possibly not shoot, don't. So, you can keep shooting until the risk is neutralized, but not keep going after that. And like I said, every situation is different. It can take a long time to sort some of these things out when you start getting into the details. So the three elements, we're going to start really talking about what the law is here. This is pretty universal across all the states. They may have slightly different elements, but traditionally, if you're going to claim self-defense, you're going to have to, or the prosecutor is going to have to disprove these. The defendant is not at fault for creating, prolonging, or escalating the situation. The second one is that you have a reasonable and honest belief of immediate danger of death or serious bodily injury, and your only means of escape is to use deadly force. And the third, which depends, is you fulfilled whatever duty there is to retreat. So in Ohio, a few years ago, they passed a law that said you no longer have a duty to retreat. Ohio is a stand your ground law state, but there are exceptions to that, and we'll get into that. But these three elements is basically, when people ask us, well, when can I shoot somebody? As long as you fulfill all these things, then at least you're justified. Maybe you shouldn't do it, but at least you're justified.
I mean, if you're waiting for us to say, here's when you can shoot someone, it's not going to happen. We're just going to keep pointing back to these video games.
Right, so if you start reading cases and there's any of this stuff's in dispute, they're going to talk about all of these. And now in Ohio, basically the prosecutor, as long as there's some evidence that you legitimately use self-defense, the prosecutor has to disprove at least one of these. They don't have to disprove all three, they've got to disprove one of them. So, the reasonableness standard. The reasonableness belief has both kind of objective and subjective elements to them, as based on the totality of the circumstances. So basically, what that means is that a person, if they use deadly force, the jury's going to be told, you need to look at that, what that person did from their point of view, and with everything that they knew, their own makeup, their physical attributes, possibly their mental state, and what was going on around them. And would a reasonable person believe that they were justified in doing what they did? And subjectively, did they have a reasonable and honest belief that their life was in immediate danger, or they were immediately in danger of serious bodily injury? So, interestingly enough, there was a case that I was just reviewing for today, and the guy that shot his ex-wife's lover said, you know, it came down to, he told the police, I really didn't think that I was in danger. He kind of got convicted. So he, you know, but that's the legal standard. You got, you know, both a kind of objective reasonableness. Would a reasonable person believe that this was justified? You know, were they in immediate danger? And did that person actually believe it? So, and subject to the state's burden, then, defendant may have to testify as to their bona fide belief of immediate danger, and plus the other elements. Again, a defendant never has to testify, but the facts could be such that this person's definitely going to get convicted if they don't testify. I mean, that's what it comes down to sometimes in a court case. Threats and words alone are not enough, but they may have a bearing on whether there's a reasonable belief of danger. So if somebody is, every time they see you, because you've got a real beef with them, and they say, hey, the next time I see you, I'm going to kill you, and the next time you see them, they are running at you with a crowbar, you may have a reasonable and honest belief that your head's going to get cracked open. But words are not enough. So somebody can be screaming in your face and calling you everything upside down, but that's not enough to use deadly force. And despite Ohio's stand your ground law, you know, you should always consider retreating if you can, if it's safe to do so. If it doesn't put you in more danger than you would have been before. And I just saw a case recently where there's a law that says that the jury can't even consider your possibility of retreating. However, there was an interesting case that came about where the prosecution got into evidence that the person could have retreated, but it was used by the court in such a way that it went to whether they were the ones that had started it, or were they escalating the situation. The appellate court said, no, they didn't use it for the purpose of showing that the person could retreat. They were showing it as the person was really responsible for doing what they did. They were the one that escalated the situation. So there's, you know, that law is fairly new in Ohio. And so I think we could take a number of years to sort through some of these things where, you know, don't think that because we have a stand your ground law, that then you can just start standing in front of somebody and escalating it, and there's not going to be consequences for that. It's quite possible that there's going to be workarounds in the law where it looks justified that somebody was purposely doing whatever they did so they could maybe take revenge on somebody. As I just said, if there's evidence presented that pretends to support that the accused person used the force in self-defense, the prosecution must prove beyond a reasonable doubt that the accused person was not acting in self-defense. And it's difficult to say exactly what that bit of evidence is, but it's not very much. All the courts are consistent that it just has to be a little bit of evidence that, if believed, then it would show that the person, that should go to the jury anyways. Because that's the thing with self-defense, is what you're asking for in a jury trial is the defense is saying, hey, I want the jury to be told they can consider self-defense. If there's no evidence out there that the person was indeed acting in self-defense, the judge doesn't have to give that instruction. And a lot of times, that's what's at issue on appeals. You know, did the judge give the proper instructions to the jury? So it's just enough evidence that if believed, that, you know, the person it could be considered by the jury to consider self-defense. So that's statutory. Person has no need to retreat before using force in self-defense, defense of another, or defense of that person's residence, if that person's a place where that person has a lawful right to be. That's the new law as of 2021. And like I said, that's the statute of trier fact shall not consider this possibility as a factor. You know, as I said, courts may find ways around that, or a good prosecutor is going to find ways to show that it indicates that somebody was actually causing the problem or escalating the problem.
Question?
Yeah.
Or defense of that person's residence. I understand the personalities here, the bodies and the persons. What about the classic case of a person, you know, with a mason jar full of gasoline or a bottle and say, I'm going to burn your house and you in it?
I think that that's probably a part of that. Yeah, it would be a part of the capsule doctrine where, yeah, if that were the case, you know, somebody's back like this, and you know, and it looks like they're going to throw the Molotov cocktail into your window, which, you know, maybe the person's got a beef against you.
Yeah.
That would be it might be justifiable. Yeah. Yeah. Any other questions on duty retreat?
When I took my CCW almost 20 years ago, one of the things my trainer said something about in regards to that if you put yourself in a situation, you must be able to notify law enforcement that at the time that your actions could be feared for your life, that statement. Is that still holding water today as far as that statement, or is that pretty much?
Well, I would say making the statement doesn't hurt.
Right.
But, you know, in a sense, you may have to be able to back that up.
Right.
You know, the facts are going to have to show that, yes, indeed, you know, if a reasonable person looks at that situation, that, yeah, I would be, as a reasonable person, I would be in fear for my life also.
It's like the scenario, if you call the police and you talk to the dispatcher and say, hey, I shot this person, I feared for my life, he broke into my house, expected to kill my wife, and the whole scenario. I mean, I want to make sure that statement still held water. That's what I was trained with.
Well, certainly making the statement doesn't hurt you necessarily. I mean, to be honest, and I'm not in the prosecutor's office anymore, so be careful what you say.
Change your back. So we're going to talk about the castle doctrine for a second.
Okay.
But if I come home and there's a drunk guy pass out on my couch, he's in my castle, right?
Right.
And if I go get a gun and I shoot him, and then I call 911 and say, well, I was in fear for my life, he's on my couch.
That's bad.
That's bad,
Yeah.
right? I still have to prove that I had a reasonable and honest belief that I was in danger of great bodily harm or injury.
Right.
So just uttering the words to the 911
No,
operator
that's not.
isn't gonna do it, but
Not all pass.
that's gonna be part, yeah, right, it's not the past, it's not like the magic phrase. But so it's still very fact specific. So
Yeah.
just saying that's not enough, but
Right.
if that's legitimately how you feel, and after review, it appears that reasonably and honestly, it's reasonable and honest, even if you're mistaken in your belief, as long as it's reasonable and honest at the time,
Yeah.
perhaps it is a justified use of deadly force.
Thank you.
Yes.
Does that review always make it to the grand jury, or can it stop right at the police and their investigation?
It depends. They don't, most of the time they're going to the grand jury, because we think that the community needs to make some of these decisions. Now, in some cases where it's very, very clear cut, perhaps doesn't get that far. But a lot of the time, they do go to the grand jury. And in those types of cases, everybody comes in, it's almost like a mini trial. And we let the community, because grand jurors are just people in the community that serve on the grand jury for 2 months at a time. We think it's a decision that they need to make. probable cause to charge them with a crime. But they consider things like self-defense and whether we think there's gonna be an affirmative defense alleged or defense of others, whatever it may be.
Probably how strong that is, what's the evidence, you know, what was happening? Did they know each other? Did they have an ongoing beef with each other versus this person broke down a door, they don't know who's in there, this is a home invasion, that, all those things would go into it. Okay, good. Okay, so those are the basics of self-defense. Doesn't change anything with cancel doctrine. Cancel doctrine is just really an additional protection for people under certain circumstances. It really doesn't change anything. Even with the cancel doctrine, you're going to get a presumption about whether you're acting in self-defense under certain situations, but if the prosecutor can poke holes in any of those three elements, then you know, you may not, the cancel doctrine may be rebutted. So, as far as the basics of those three elements, any questions before we go on to this? Okay. So, cancel doctrine is a doctrine that's existed for many years. It used to be under common law. In Ohio, it was by statute. In some states, the cancel doctrine can be different. There may not be a statute, or I believe there are a few states that don't even recognize the cancel doctrine to any great extent, or it's highly limited. And I'm not familiar with all of those states, but it does vary by state. So in Ohio, it covers both your residence and your vehicles that you're driving. It would also cover a place that you're staying as your abode for the night, so it's like a hotel room. It may apply if you're staying, say you're staying with a relative or something, so you're staying in their home. It covers an attached porch by statute. The statute even says if you're in a tent, it covers you. Strange, but it's true. So it covers a number of different things. It's fairly far-reaching in Ohio. I believe obviously in the 80s and 90s there was a rash of carjackings, and I think that those are still obviously still out there, and in some areas it's worse than others. But I think that's why they included vehicles, because to address the rash of carjackings around there. So it provides a statutory rebuttable presumption that if some certain things happen, that you are acting in self-defense. It doesn't give you an federal right to use force in self-defense, and it can be, like I said, it can be rebutted by the prosecutor if they can establish certain facts, whether it's you didn't have a reasonable cause to believe of immediate danger of death or serious bodily injury. Maybe you started the assault that was going on. So those can be rebutted easily. Those can be rebutted as to get around this. Person is presumed to have acted in self-defense when using defensive force against somebody that is in the process of unlawfully and without privilege to do so entering, or has unlawfully and without privilege to do so entered the residence or vehicle occupied by the person using the defensive force. So it's important to note that the statute doesn't require you to let the person into your car or your home. If they're in the process of entering, you may have the benefit of castle doctrine. It's the whole thing of, well, if I shoot somebody and they're halfway in the window and they fall back out, do I need to drag them into my house? No, you don't. They were in the process of entering, and this kind of circumstance can happen, certainly. Somebody's trying to get in your window, you tell them, don't come in here, I'm gonna shoot you. And they just keep coming, and they get shot, and they do fall out, possibly. You don't have to let them in, because obviously letting somebody into your house is going to be create a whole lot more danger for you. So the statute covers you. Okay. The two elements of self-defense still apply. The other two elements still apply. However, especially in your home, you really have, even before we changed the statute, you never have a duty to retreat in your home. So even before they changed that in 2021, you had no duty to retreat. But again, if a prosecutor could show that that was the most reasonable thing for you to do, they may be able to show that you didn't have a reasonable, honest belief that your life was in danger. It just depends. We have to see if the facts, if a case comes up like that. The biggest problem in these types of cases are where you've invited somebody to your house. We see it all the time. There's lots of cases out there where people get invited over, people are drinking, they get in arguments, one person tries to throw the other person out, and all of a sudden fights ensue, guns come out, people get shot. Those are difficult cases, and they probably do not invoke the castle doctrine. Some people, because I've seen it, there's cases out there where they say, hey, I told the person to leave, they wouldn't leave, and so I shot them. They don't get the presumption because the courts have said that, no, they were an invitee. They had a reason to be there. They had the privilege that they didn't under the statute. It says it's without privilege. They had a privilege to be there. Doesn't mean you can't defend yourself, but you may not get the presumption of self-defense under this statute. You may have to go to court and prove a lot more, or maybe the prosecutor has to disprove a lot less. It just depends. But oftentimes in those situations where kind of the guest has gone bad, you get fights, and somebody uses force, the courts will say, you don't get the castle doctrine. You can still prove self-defense, but you don't get the presumption. And the other difficult place is domestic violence issues. Again, if both people have a right to be in the home, nobody has to retreat, but that's part of the problem with domestic violence is, frankly, nobody's having to retreat. People are duking it out sometimes, and it certainly makes the cases very difficult if somebody gets shot. But the castle doctrine, again, may not apply, but those are certainly difficult cases. Yeah.
I have a full bar, I can say I come home from work, there's someone trying to break into my full bar, how's that work?
Okay, the question is, what about a building that's an outbuilding? Castle doctrine does not apply. You can still defend yourself, but you're not going to get the presumption of the castle doctrine. Yeah.
What about places of work or places of worship?
Places where you work, I think I've seen old cases, because you don't see it that often, but a castle doctrine type of thing may apply, say if it's your business. It's not covered directly by the statute, but there is an old case law like that. Place of worship is probably, a church is not going to be similar. I mean, that's really no different necessarily than like a commercial establishment. So if you're in there, you wouldn't get that presumption. Any thoughts on that?
I haven't been to the workplace either.
Yeah, I think if it's your own business and you're there, you may have an argument for that. But yeah, just generally, just a business where you're employed, it's not going to cover you.
Who's providing the prosecutor or
Well, it's a presumption under the law. So if someone breaks into your home and they get shot by you, you have even less to prove. Automatically, they didn't have, they're a third party, not somebody that necessarily has a right to, if they don't have a right to be there, law is gonna say, you acted in self-defense. Prosecutor has to disprove that, just flat out.
It's a jury instruction, so maybe we're going to jury for a decision, or even for a grand jury process, it's an instruction that you read that a person is presumed to have acted in self-defense with the following things apply. We're gonna instruct, it's an instruction.
There's a question over here? Oh, yeah, sorry.
Yeah, this gentleman stated that, an outbuilding, if I correct this right, if you drop your garage, and somebody comes in, like, the bottom of the not covered, but it's half full,
Is it an attached garage?
no, it's detached.
You're not gonna have the castle doctrine. You can defend yourself, there's no doubt about that, but you may not get the presumption of the castle doctrine.
Really, if you won't build a tree, I mean, if I say, you're working on a car, and somebody got a gun in their head, that's like a gray area.
Well, certainly in that circumstance, it's just somebody that you don't know, they come in, they're there to rob you or do whatever. I wouldn't even be worried about the castle doctrine, because you're gonna be able to defend yourself.
I thought it was just property.
No, it's not your whole property, certainly not.
It's not saying you can't defend yourself, but you're not gonna get this presumption of the castle doctrine.
Yeah, so you don't get that jury instruction.
If the other elements are still met, still, yeah, it's self-defense.
Just like somebody's stealing your car in your driveway, you can't go shoot them.
That's true. Yeah, we'll talk about that potentially. That's defensive property, so you can never defend property with deadly force.
Quick one, she had a very good question. The grand jury in Summit County, in a situation with the castle doctrine, how many cases are no-bill that don't go forward?
So the problem with your question is that a lot of those cases are not charged, meaning the person's not arrested, and we then take it to the grand jury. And this, one of the main reasons why grand jury is confidential and there's this element of secrecy to it is to protect the reputation of the folks who are not indicted. So there are cases that go just like this, where there is no indictment returned because the jury feels that they're acting in self-defense, and to charge that person is not appropriate. But those aren't things that are available on the clerk's website or published anywhere, because it was not something that was charged. It was just taken to the grand jury, and it's called a no-bill, and those are secret for a lot of reasons. One, to protect that person's reputation, and we don't broadcast, well, hey, this person wasn't charged with a crime. That's the rules. We don't publish that.
Curious, because you've been grand jury now for at least several years, right? 7 years. In that time, how many castle doctrine cases have you seen? Can you give a quick estimate?
I can tell you that the supervisors were in 2 last year that I can think of. I can't tell you in 7 years, but I can think of 2 that were last year. Those were uncharged individuals where something happened. The police then brought it to prosecutors, and Prosecutor Kolkovich normally comes to these, but unfortunately he got tied up. He just got a text, he's not going to make it. But he and our criminal division chief will typically review these, and one of them will often take it to the grand jury. But all these instructions that we're talking about, we give them all the law, and they decide if the person gets charged. I think we did 2 last year where they were not charged individuals. Something happened, it was reviewed, it was taken to the grand jury, and the grand jury at the time decided not to charge those people with crimes. Based on, one was castle doctrine, and the other one was typical self-defense.
Yeah, so these things don't happen that often.
There's only 2 I think that were last year, or the person got it.
So they don't presume it at, like, when the police get there, at the initial investigation, they're not.
Most police officers are aware of this doctrine, but it's not really their job to interpret this. But they all have, there's law departments for each department, there's prosecutors that help them, and when the lawyers get involved, we're typically talking about, well, what is the evidence support?
So in that case, like, could I be arrested and held, or like what?
We have had cases where the police charge somebody, and then upon review and taking it to the grand jury, that person is not indicted, and they are released, based on these kinds of principles. But oftentimes where the police, where they're thinking, this might be a self-defense or a castle doctrine, they may not charge the person, and they're gonna talk about whether a lawyer is assigned to their jurisdiction or municipality, and that's when sometimes you say, well, you just need to go to the grand jury and see what the judge. The person's not in charge, not being held. And in those cases, a grand jury, we can always invite the person who's charged to testify, we can never compel them to. But in those kinds of cases where we think they may be allegedly self-defense, those are the kind of cases where we may call their lawyer and say, hey, does he or she want to come testify and tell us the entire story?
Sure.
That goes with, you know, you've seen on the national level where a situation occurred and two people were involved in an incident and somebody is shot and injured or shot and killed, and the person that did the shooting was not arrested, and you wondered why were they not arrested, and you're thinking, that's an open and closed case. That's where these laws come into play. Law enforcement, if there is a doubt, as long as we don't suspect that the shooter is going to take off, we are going to investigate, turn it over to the prosecutor. The prosecutor will take it to the grand jury, and those citizens will make that decision as to whether to true bill or no bill. And if they true bill, then that person is, they're indicted, of course they're arrested, and then they go through the whole process. But that's why sometimes you see on the national level, an incident occurs, but the person isn't arrested and you just don't understand why. It's because there are circumstances in that situation that you're not being told, because you never get the true story from the news media.
Thank you.
Let me just put it this way, you don't get the whole story. But you don't get the information that you would need to make that decision. And the law enforcement officers that do show up, they have the information, and that's why it has to go through that process. But if there is even, quite honestly, if there's even a question where it looks like, you know, the interaction is real hokey, and we're getting, our spidey senses are going up basically, and they're going, there's something wrong with the story, then we may arrest you, and then let it play out.
So before I start talking about, because I have a bunch of cases that we can talk about while we still have time, let's talk about defense of others, because this is one of the areas where I think when people get their CCW or they're carrying a gun, it kind of in the back of their mind is, I think the sheriff was alluding to earlier, that, you know, people think, oh, man, I'm going to save the day for somebody. Defending others is just totally fraught with problems, because you have no more right to defend a person than that person had a right to defend themselves. Being a qualified adult or having a CCW license doesn't make you a deputy, doesn't give you any additional rights, and frankly, the law discourages taking the law into your own hands. You can certainly have a problem if you see something happening and you decide you're going to pick which person caused it and which person's the aggressor, or which person's the aggressor. And if you pick wrong, you've got a world of problems. And that certainly can happen. It certainly can happen in domestic violence cases, or really anything happening on the street. You don't know what's going on. You know, it could be a bad guy and undercover police officer. They're wrestling, and he's trying to take them down, and you pick the wrong person and shoot somebody and either hurt them or kill them. So be very careful if you think you're defending other people. Now, of course, the question always comes up, what if I'm sitting in a restaurant and somebody comes in and starts shooting? That's a tough situation. In that, do you know really what's going on? Certainly if they're indiscriminately shooting, as it has happened before, you can defend yourself, especially if you think they're coming around to you. But again, if somebody's sitting in a booth, there's two people people sitting in a booth, one person pulls out a gun and shoots the other person. Do you really know what's going on? At least take that half a second to maybe figure that out and see if they're gonna start turning the gun on other people. Because again, you don't know what happened. Could it be that, again, could it be a police officer and a bad guy? The bad guy gets shot because he was getting ready to pull out a gun that you never saw. It's hard to say. There's all kinds of factual scenarios that you can think of where defending somebody is not going to be the right person that you're defending. So, I mean, I don't want to go into this in great detail. The law would say that if you objectively are doing something reasonable, maybe, you know, you're not going to get held to as high of a standard, but still, if you pick the wrong person, if the person you're defending is actually the one that caused the situation, you're going to be at least have committed some type of homicide, potentially, or an assault, felonious assault. Go ahead, next one. Defense of property, we kind of talked about it a little bit. You can't just defend your property. So if somebody's stealing your car out of the driveway, you can't open the window and take a shot at them. Now, people will tell you, well, you know, you've got a right to defend your property in some way. Can't you go out and try to stop them from doing it? Technically, and under the law, you probably can. But I think it can be a really bad decision to do that. You know, do you want to be right under the law that I can go out and try to stop them, but from a tactical standpoint, you know, they may be able to overwhelm you. They may have an accomplice that's hiding somewhere else, keeping an eye on what's going on. So you're at a tactical disadvantage, and you're now going to be the one that gets shot or beat up, and your car's still going to get stolen. So you have to be very careful in those types of situations where you think, hey, I'm a man, I'm going to go out and protect my car, but you're going to put yourself in a really bad situation. But certainly you cannot just shoot at somebody because they're stealing your car. If they're committing a felony, you can do the Barney Fife thing and do a citizen's arrest, but you know, there's all kinds of problems with that. Any comments, any? Okay. I did want to note that the Ohio Attorney General, most of you know, especially if you have a license, they used to put out these books that look something like this. They no longer publish these, but they are available on the Attorney General's website. If you Google Ohio Attorney General Concealed Carry Manual, it should be about the first thing that pops up. It's got a good summary of everything we've been talking about. I highly encourage you, to look at the most updated one, because those have changed over the years. So the ones that out there has all the new laws in it. I think they even give you some examples in there. I've always thought it was pretty well written for what it is. So I encourage you to do that. So I wanted to talk about a few cases that kind of popped up, because I think are kind of interesting to give you some sense as to things you may want to look at. Oh, yeah.
So it says contrary to the castle doctrine, but it says on here that the Ohio statute covers residents and vehicles.
Well, yeah, I should have mentioned that. So the contrast there is if you're protecting something that's not in your home, or frankly, even in your home, that's one of the things we didn't talk about. So somebody breaks into your house, you come downstairs, they're running out your front door with your TV. Their back's to you, can you shoot them? No. The answer is no. At that point, there's no immediate threat to you. They've got a TV in their hand. They're certainly probably not going to be pulling a gun to shoot you. And if you're shooting them in the back, the castle doctrine is going to go away for you. Same thing with anything that's outside of your home, whether it's an outbuilding, your car's in the driveway. Now, a different aspect of that, though, is we've had this question come up. Well, somebody's in my house, they start running, but maybe they're running to where other family do you see a weapon? You know, what's going on here? This is where all these facts may come into play as to whether you're really justified in shooting somebody that's under the council doctrine in your home, as to whether are they really a threat, or are they trying to get out of your house? I would say that most burglars, not all though, they're there to steal things. They're not there to hurt you, to be honest. Although that happens. So it's one of those odd areas where you have to use a lot of judgment in a split second. Figure out, do you want to do this, or are they going to run out the door and it's not going to be a problem for you? I can't give you a set answer. It's going to be all these things that you take into consideration. Are they going to go into your kid's room and now they're going to hold your kid hostage? That's a problem.
To your question though, where it applies to homes and vehicles, if you're in your car, you're gonna have that same presumption.
Yeah.
But not like in your car, you're driving. But if you're in your car and someone's trying to unlawfully enter it, it applies.
Any other questions? Okay. So this is an interesting case that actually relates to the castle doctrine. This was State versus Caracillo. This is out of Columbiana County. So this is a drug dealer. He has all kinds of drugs in his house, has all kinds of money in his house. His friends all know that his drugs and money are there. And his friends decide one night they're going to rob his house. These are his friends. Hate for them to be my enemy. So he gets wind of it from somebody else. Because all the friends are talking, and one of them says, "Hey, Bubba's gonna come over to your house tonight and steal your money and your drugs." Well, he says, "Hey, great! I'm gonna lay in wait, and then I'm gonna shoot him." So he allowed. Basically, there was actually the facts are longer than this because he was waiting for him one night. They didn't show up. Waited another night. They showed up. So he's waiting for him, and it was actually his girlfriend or his ex-girlfriend, I'm not sure which, started coming through the window because she was part of the group that was going to rob him. And he shot her, killed her. And he said, "Castle doctor, they're coming to my house to rob me." Judge says, "There's no way, I'm not giving that instruction. You were laying in wait, you knew this was happening. In a sense, you almost caused this to happen. You let these people come, you shot this person." So it's certainly an interesting case. There's a lot of facts there, but this is one you can look up on the Supreme Court's website. I'll even give you the case site too if you want to write it down, if you want to read the facts. So it's amazing what happens with drugs and money and people that all deal on this. There's no honor among them, no honor among these thieves. But it's if you look it up on the website, it's 2017-Ohio-8160. You can look at this case and see what you think. So that's the first one. That's Castle Doctrine, where the Castle Doctrine didn't work. I think he thought he had a get out of jail free card, and he didn't. Let's see. I did want to talk about a couple cases that you made. If you want to talk about them, you may remember them. There was the pizza shop guy down in Cotton Falls. I think his name was Strong. I think that's how you say his name. But if you recall, this was back in 2019. Pizza shop down on State Road, Cotton Falls, and they had a tip jar there. Well, Strong was out of the shop. He came in, and his employee said, "Hey, that guy that's kind of wandering around came in and grabbed some money out of the tip jar and took off." So Strong went to look for him. He was down on State Road, and he found who he thought was the guy. And he confronted him, approached him, confronted him, said, "Hey, you stole my money, give the money back." and the guy, they got into an argument, obviously, and this is the type of case where, fortunately, no one actually got hurt. Strong went to jail. So Strong had a gun on him. He said that this guy was, going to attack him, or was attacking him. The guy, apparently, from all the witnesses, said it was actually walking away from him, and he shot in the air, and Strong was, the police came, arrested. He was charged with, I think it was an attempted felonious assault, and you're not allowed to just discharge a gun, period, like that. So, he claimed self-defense. Nobody bought it. No witnesses said, other than him, that this guy was, a danger to him, and so he was convicted. So that's a case where certainly you got to be careful of that. If you're going to use a gun in some way and claim self-defense, you actually have to meet those elements of it. He didn't even get very far with that. And another one where this was a prosecution that our office did back in let's see, what year was this? You may recall the dirt bike case where this was William Knight, and I think it was his son-in-law, had his dirt bike stolen. So his son-in-law was watching the ads to see if somebody was going to sell it. Sure enough, somebody was trying to sell his dirt bike. He went up, took Knight with him, and Knight had just gotten his concealed carry license, just bought a gun, never shot it before, and apparently had very little experience with guns. So he takes Knight with him, and they go look at the bike. Yeah, they were going to buy it. Yeah, and guy says, the son-in-law says, "Hey, this is my bike. I'm taking it with me. This is a stolen bike." And the guy that was selling it, he said, "Hey, I don't know anything about that. I got it from somebody else." And so he was on the bike at the time. There was a bit of a back and forth. The son-in-law had grabbed the handlebars or the bars, I believe, and the guy eventually was able to take off. Drove down the street. It was a dead-end street, so he had to start coming back the other way to get out of there. Knight, in seeing all this, and was probably a good, I think it was about 100 feet away from this guy. This guy was nowhere near his daughter or his son-in-law, who were both there. He took one shot with a snub-nosed revolver, and at that distance, hit the guy in the head and killed him. Yeah, crazy. You couldn't do that if you tried. But, so he claimed self-defense. Again, his self-defense claim didn't fly. The person was too far away. There was no immediate danger to him, his daughter, his son-in-law. It was just, he didn't have the wherewithal to deal with a stressful situation. This guy probably shouldn't have had a gun. I believe that at the trial it did come out that he was a bit of a hothead, or that he couldn't handle stressful situations. And this was certainly one of them. But it's a cautionary tale. These types of things happen. People get put under stress. They've got a gun. They decide they're going to pull out their gun. For all I know, maybe he even thought that he was going to stop the guy just by shooting and not hitting him, but he ended up hitting the guy. So very bad situation. I remember this trial going on. I think it was Brian and John that did. Yeah, Brian LaPrenzi and John did this case, but yeah, bad situation.
I know you weren't able to look up my garage. Is the same
Troy, this is one of the things I want to add to the PowerPoint because I forget every single time. I told you earlier that if you're a qualified adult, you have identical rights and responsibilities as a permit holder. There's one tiny caveat to that, and it's school safety zones. So in Ohio, if you have a school safety zone and you're a permit holder, you can have a loaded gun, but it has to stay in your car. Your car has to stay locked. It doesn't apply to permit holders or to qualified adults. So qualified adults, you can't have a firearm in a school safety zone. And that applies to the school and anywhere where there's a school function, all the school grounds. So even if you're just like driving in to pick up a kid, you can't have a firearm in your car unless you have a permit. And then it has to stay in your car. That is the only distinction.
Yeah, that relates to the federal statute. There's a weird interaction between the federal and the state statute. And so you've got a permit issued by the sheriff. You can take your firearm in your car, into the parking lot, and be there as long as the gun does not leave the car. So don't take it out and put it in the trunk. It's got to stay in the car. So, you know, you've got something rigged that you can't get it off, you're going to have to stay in the car. But if you do want to get out, you gotta take it out of the holster or whatever, and leave it in the car and keep the car locked. But you have to have the permit, not qualified at all.
So that's the only difference. Other than that, qualified adults have the same rights as permit holders.
The launchers, you ever hear the burn up launchers?
Sorry, I can't hear you.
The pepper ball guns, what are the rules and the laws of those?
I don't know that, because those are, I think those are probably non-lethal, although.
They're not lethal, but they're considered a weapon, but it's still.
Yeah, I don't know offhand what that is, but you're probably not gonna have the same rules for use of that, and I'm guessing you don't need any type of license to carry. Yeah. It looked like a.
What other differences are there between having a concealed carry permit and the new law?
Just the school safety zone.
That's the only difference?
Well, yeah, obviously reciprocity. I mean, if other states don't have our laws, you're responsible to know the state's laws where you're going with a weapon.
I think the only other thing would be, some gun stores, because now our permits are what's called mixed certified or mixed qualified with the FBI. Some gun stores, they'll take your license as identification, and I don't think they're required to call in to NICS to verify the form. But a lot of them still do, because they don't want the liability.
I would say that those are just more things that are benefits to having a permit, not necessarily differences. It's just a benefit to having a permit.
Right.
And those of you who have permits and carry out of the state of Ohio, before you do, you need to get on the website, take a look at reciprocity in the states that you will be driving through, because not every state permits you to have a concealed weapon. So you do want to take the time to do that. And if you do not have a permit, Ohio permit, CCW, you are not permitted to carry a gun concealed outside of the state of Ohio. So you cannot, you get accustomed to doing it here, you cannot take it on your person or concealed in your vehicle into another state. The only way you can do that is if you have a permit, and you need to check the states to make sure that they accept Ohio's CCW license.
Yeah. The only exception I would say is if that state also has a constitutional carry, which some of them do, and they allow non-residents to partake in it. So I think there are some states that have constitutional carry, but it only covers residents of that state.
Yeah, we're the 23rd state to be a constitutional carry state. So, I mean, if you're on a road trip, you're passing through multiple states, and you wanna take your gun in the car, you need to check every state you're gonna drive through. Because if you get pulled over in that state, they're usually not gonna care if you say, well, in Ohio, you can do this, because you're not in Ohio anymore.
But I guess the difference with it being constitutional carry, Ohio has been constitutional carry, it's just now you're allowed to conceal that weapon.
No, so we didn't become a constitutional carry state until the summer of 22. Prior to that, we were a permit state, starting in 04.
For concealed.
For concealed carry, permit.
We have always.
And open carry.
Open carry.
Right, open carry, right.
Yes.
But the